Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. We have a question here from YouTube user Charonica Niels, 6105, who asks us, "Hey Vince, I seriously need your feedback. My employer lied in the position statement saying I quit my job." Pause. We have a video on the channel about lies in the position statement being an opportunity. I highly recommend you hit up that video. I think it's a great video. Read it, view it, watch it before you do your rebuttal. Tronica goes on. "Truth is, I was fired after showing a doctor's note stating that I was pregnant. I showed text messages to the Equal Employment Opportunity Commission and of me informing my employer that I was in fact pregnant because they claimed to have had no knowledge of me being pregnant. I then got a call from the EEOC, the Equal Employment Opportunity Commission, asking me to upload the note to my portal, and my case is still in investigation. I do not have an attorney yet. What is going to happen? It's been almost 7 months since I filed. How long do cases like this take? They did not want to mediate, but the employer lied. I showed the messages." Okay. Statistically speaking, overwhelmingly likely, you're going to get a right to sue letter. Clearly, you're in the right. Clearly, your employer's a liar, and their pants is on fire. They have no credibility, right? You can demonstrate that, and you can use that position statement to make them look the fool. Tremendous. You're in a good position. But when you get that right to sue letter, you're going to have 90 days. A mere 90 days from the day you receive that right to sue letter to get filed in federal court. 90 days might sound like a long time, but it's actually occasionally difficult to find an employment attorney in those 90 days and then give that employment attorney enough time to get everything done to get filed in federal court. It can certainly be done, and it routinely is done, but I'm going to underscore for you here that a lot of people call me up and say that it's nerve-wracking and they wish they had more time. So my recommendation to you is, 1, hit up our damages calculation playlist and get a demand to the EEOC investigator. Tell them what you want, what you would take to settle your case. If you would. If there's a settlement figure that lives in your heart that you would accept to be done with all this, get that to the investigator and ask them to convey it to the respondents, convey it to the defendants, convey it to your your ex-employer. Now, after you do that, do not sit on your laurels. You've got a rebuttal to be working on, it seems. Get to work on that. But also schedule 3 to 5 free consultations with local employment attorneys. Get a feel for the market where you are. Get an idea of what's available. Get an idea of who you might want to work with. Keep in mind, these cases can take a while. If you are on your own, the EEOC, listen, I've seen it take 4.5 years. Represented by counsel, generally far, far faster. You're going to be looking at 6 to 9 months. So 18 at the outside. So that's not the only reason to hire an attorney, but it's definitely one reason why you might want to hire an attorney. And while the defense percolates and thinks about your demand, maybe gets you a response, in the meantime, you're working on that rebuttal. You're getting your ducks in the row. You're lining up counsel. If you don't like your local options, talk to the national options. But the national options tend to be a little bit more expensive, such as our firm. So I often push folks towards the local options first. Exhaust your local options first. And only then, if you're not comfortable with your local options, should you really look into the national options. Is that good for me? No. Is it good for you? Yes. I think it's good advice. Now, that's what I'd be doing at this stage. Get a demand in. If you can settle your case without hiring an attorney at all, great, because you don't have to give somebody some percentage. I don't know, it's 33, 35, 40, whatever percentage the firm you work with wants, right? Keep it all. Why pay us if you don't need to? But don't count on it. Be ready, because if you're not represented, they might not take you seriously in the settlement process, and that's going to lead to kind of hard choices for you. Do you take a settlement far less than you think you deserve because you're not represented and they're not taking you seriously, or Do you hire an attorney and assume they're going to benefit you more than whatever their percentage is going to be of what they win for you? That's a tough call. Most of the time, I tell folks to just go ahead and get an attorney, but it can be a tough call. And Sharonica, I get the feeling that you're pretty on top of things, so maybe this is, you probably could do the settlement on your own if you really wanted to. Do I think you might get more with an attorney? Yeah. But feel it out. Get an idea what the response is to your demand, right? I mean, it's a big part of this decision-making process. A little scouting, a little fact-finding. You can learn a lot from a conversation, even if that conversation is primarily being held by the investigator and you're only hearing about it secondhand, right? I get it. They already turned down mediation. So what? You can still make a demand. You don't need to sit in a room all day to make a demand, right? Don't make a crazy demand. A zany demand, I should say. Zany, not crazy. But, as long as your demand is rooted in the actuality, the factual way the damages in this field are actually calculated, then I think that's a tremendously good idea. That's what I'd recommend for you. What else can I tell you? I presume you're still pregnant. Hope that's going well. So 7 months has passed. Maybe you're not. In which case, I hope congratulations are in order. I'm going to track the comments on this video in case you have follow-up questions. If you do, in the question, just remind me that you're the original poster. Tell me what your follow-up questions are. I will try to make you a follow-up video because, one, I think you're at a crucial point in your case. Two, I think you're doing really good work, and I want to make sure somebody's supporting you, even if you don't have an attorney. Listen, I'm not representing you. I'm not your attorney. This is not an attorney-client relationship. All the disclaimers. But if I can answer a question for you for free that helps you get this done and get made whole and get paid and get that fat check, then let's do it, right? And that leads me to my closing remarks. If this video was helpful, and it might have been helpful. If it was, like, subscribe, comment down below. If it wasn't, I deserve that thumbs down. Give me the thumbs down. But if it was, you can comment down below. It's always helpful to have conversation from folks, like cross-conversation, like, hey, this is what I did in my case, this is what I did in this case. You might want to think about this. Oh, the damage calculation playlist is good, but, I did things a little differently. Like, open to all that crosstalk. I think plaintiffs helping plaintiffs is incredibly valuable. We sleep on it as an industry. There's YouTubers who do an amazing job. The Fight Employment Discrimination channel does an amazing job in which a plaintiff helps other plaintiffs. Tremendously useful, tremendously intelligent. I always regret my collaboration with that channel because I think I did a bad job. I think I came in a little underprepared, and she did an amazing job, and I feel like I let her down a little bit. It's a good collaboration. I like those videos, but I think it could have been better had I been better, had I been more prepared. Not her fault, purely mine. Anyways, everybody take care. Like, subscribe, comment down below, share the channel so it may grow. Take care.